What's up, everybody? Garrick Rummel here with Duty to Train. I wanted to pick up where we left off, and I actually just started recording a video, and I need to start being more concise. And so I started going down this tangent and realized like it wasn't becoming a good video. So I'm restarting it, but I wanted to pick up where we left off from the last video, and that is trying to figure out what the founding fathers meant when they wrote the Second Amendment, right? Everybody has a whole lot of, you know, he said, she said, this is what I think. I'm trying to go straight to the source documents and figure this out so I can just tell people, like, go watch my videos. I don't, however many it's going to take, I'm going to figure this out. And there's a way to figure this out. So that's what we're doing. And so I just searched the same thing that I searched last time. What did the founding fathers say about the Second Amendment? And I clicked on this one before. We went to this Washington Post garbage article, tore that apart. And then I found this Duke University, a linguistic analysis of the right to bear arms. So I was like, okay, that sounds promising. And so this is 11 pages long, and it might take a little bit, but I think that this is the type of thing that, frankly, if you want to learn about the right to keep and bear arms, like, this is the history. Like, you have to go into this, and nobody goes into this because, like, oh, it's all boring, and maybe nobody ends up watching this video, but it will give me the ammo to explain to people that I have done my research and I have looked into this. And if nobody ever watches that, or if nobody ever watches this, that's totally fine. But this is the ammunition I need to defend my right to keep and bear arms. And so even if it's a little bit boring, I'm going to do the work. So also, look at this lighting. Sick, right? I'm finally, like, I moved my studio around today. And so I have, like, a sweet little setup. Got some purple over here, some blue over here. I'm starting to look a little professional. Far from, the final setup, but this looks way better than it did last night. Sick. All right. So what the framers intended, a linguistic analysis of the right to keep and bear arms, by Stephen P. Holbrook. Introduction. In 1775, and I looked this up. All right. Thomas Gage was a British general who successfully commanded the vast British military machine in North America for more than 10 years, between 1763 and 1774. This says in 1775, so maybe he wasn't, like, commanding the army. I don't know. But he was a British general, and he ordered that all private arms in Boston be deposited with the magistrates, supposedly to be stored temporarily and eventually returned to the owners. So pretty straightforward. He said, hand me your guns and eventually we'll give them back to you. Those citizens naive enough to comply with the general's edict turned in 1,778 muskets, a bunch of pistols, bayonets, and blunderbusses. Blunderbusses are those big old guns that you saw in Beauty and the Beast, like, no one shoots like Gaston, dun, 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 like Gaston. It's like that big gun that had, kind of barrels out at the end. So anyway, side note, they accordingly delivered up their arms, but in open violation of honor, the governor ordered the arms deposited, as aforesaid, to be seized by a body of soldiers. One newspaper published a poem entitled Tom Gage's Proclamation. I read this, like, quickly before. It kind of just craps on Thomas Gage. But at the end, it says, meanwhile, let all and even and every one who loves his life forsake his gun. Which is saying that it was like what a poem titled Tom Gage's Proclamation. So they're saying this is what he said. Meanwhile, let all and every one who loves his life forsake his gun. Anyway. In a recent article, Professor Don Cates acknowledged that the Second Amendment right of the people to keep and bear arms, right here, protects an individual right to keep arms in the home for self-defense. He contends, however, that the amendment serves to guarantee the right to carry them outside the home, only in the house, only in the course of militia service. So he's saying, unless you're, it says, because the Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. He's saying that because it says militia, you can't bring your gun outside the house unless you're working for a militia. I would argue that every time I'm stepping out of my house, I'm my own personal militia, but whatever. In that article and in this dialogue, Professor Cates argues that the following arms may be completely banned from private ownership: And I'm just gonna be honest. I want to be honest in my arguments as well. When the founding fathers were talking about a militia, I do not believe that they were talking about everyone is like their own personal militia. I don't know exactly what they meant. I don't think that that was what they meant. So that was kind of like an offhanded comment, but like that's the type of thing that frankly, you know, I don't know, this is like a serious topic and I don't want to like make comments like that lightly. So I was joking. I just want to acknowledge that. Okay, so he's saying that all these different types of weapons should be banned. Gangster weapons, brass knuckles, switchblade knives, and short-barreled shotguns, purely offensive military weapons, and the urban possession of rifles, shotguns, and highly penetrative bullets. Lastly, Professor Cates contends that I don't really know what he means by banned from private ownership. They may be completely banned from private ownership. The urban possession of rifles, shotguns, and highly penetrative handgun bullets. I mean, every bullet is arguably highly penetrative. And if you can't have highly penetrative handgun bullets and you can't own shotguns and you can't own rifles, I don't know where this guy's going. Hopefully this guy tears this apart. Lastly, Professor Cates contends that permissive licensing and registration for gun ownership is constitutional. So if you want to purchase a pistol, the state is legally allowed to say, hey, you have to come to us for a permit first so we can like run a background check and stuff like that. Did the framers of the Second Amendment, as well as all those of the 14th, intend constitutional protection of the right to bear arms to encompass the private carrying of arms for self-defense? What arms are protected under that guarantee? May licenses and registration be required? Okay, so he's going to hopefully address all of this. The following analysis seeks to resolve or at least clarify these queries. Okay, all right. I don't know if this is going to fall on the pro or anti-Second Amendment side, but let's see what happens. Did the framers intend the Second Amendment to encompass a right to carry guns for self-protection? Professor Loren Kress, who speaks for himself when he claims that we know little about the Second Amendment's reception in the states, has recently argued that the founding fathers would have been shocked by the idea that citizens could bear firearms for self-defense. Professor Cates bases his similar argument that there is no right to bear arms outside of militia service on an unpublished. Okay, so this sounds like a better argument than the Washington Post one. It's going to be much more complex, but I'm going to go through this. Frankly, I'm going to go through this line by line. This might end up being a very long video, but I'm going to go through this line by line. And I know the Second Amendment pretty well. And I know at least when someone's making a poor argument, just like if you can't have rifles, you can't have shotguns, you can't have highly penetrative handgun bullets. I don't know what that definition even means. What are you allowed to have? He's saying that, you know, the Second Amendment protects an individual right to keep arms in the home for self-defense, but then he goes on to argue that the following arms may be completely banned, arguing that the urban possession of rifles, shotguns, and highly penetrative handgun bullets, which he's not saying handguns, but he's saying highly penetrative handgun bullets. All bullets are highly penetrative, right? Stupid argument. Okay, so this sounds like it's going to fall on the anti-gun side. I don't know if that's true. Maybe there's like two sides of this argument, but I'm going to start, picking this apart because, I don't know, we'll just see where it goes. Okay, let's zoom this. There we go. Let's zoom that in a little bit. Okay. That makes it a little easier. Okay. And this actually isn't as long because there's a lot of like notes at the bottom. So it's not as long as it looks. Did the framers intend? Okay, so Professor Cates bases a similar argument that there is no right to bear arms outside of militia service on an unpublished thesis of a law student. Great. Not on Supreme Court justices for the last 200 years. Professor Cates bases his similar argument that there is no right to bear arms outside of militia service on an unpublished thesis of a law student. I don't know. Yet Kress and Cates are well aware that the first state declaration of rights to use the term bear arms was that of Pennsylvania in 1776, that the people have a right to bear arms in defense of themselves and the state. Okay. Interesting. I did not know that. Okay, so now they have to argue that. Interesting. Let's see where this goes. That to bear arms means simply to carry them was clear in a game bill drafted by Thomas Jefferson and proposed by James Madison. Okay, so that to bear arms, this is important, that to bear arms means simply to carry them was clear in a game bill draft. I don't know what a game bill is. Maybe that's just like a first draft. Drafted by Thomas Jefferson and proposed by James Madison, draftsman of the Second Amendment in the Virginia legislature. The bill would have fined those who hunted deer out of season, and if within a year the hunter shall bear a gun out of his enclosed ground, so carried the gun, unless whilst performing military duty, he shall be in violation of his recognizance. So let's read that again. The bill would have fined those who hunted deer out of season, and if within a year the hunter shall bear a gun out of his enclosed ground, unless whilst performing military duty, he shall be in violation of his recognizance. The game violator would have to go back to court for every such bearing of a gun to be again bound to his good behavior. Okay, but this sounds like it's combining the two things. The bill would have fined those who hunted deer. This is very important in legal terms, the difference between and or. I'm not a legal expert, but it's a very clear distinction in legal jargon, the difference between and or. So you have to pay attention to what this is saying. The bill would have fined those who hunted deer out of season, and so you have to hunt deer out of season. That is the first part of this. So if you hunted deer out of season, and if within a year the hunter shall bear a gun, so carry a gun out of his enclosed ground, unless whilst performing military duty, he shall be in violation of his recognizance. So basically what they're going after is people who are hunting deer out of season, and they want to make sure that if you're carrying around a gun within a year of breaking that law, that they could fine you. All right. So this isn't just saying you're not allowed to carry a gun outside the home. What they're trying to go against is hunting deer out of season. I didn't know they had deer season way back then. So the violator would have to go back to court for every such bearing of a gun to be again bound to his good behavior. Thus, in the minds of Thomas Jefferson and James Madison, to bear a gun meant to carry it about in one's hands or on one's person. As for instance, and James Madison, I just want to make sure I'm not making a stupid mistake here. Who penned the Constitution? James Madison. Yeah. Though James Madison wrote the Constitution, he certainly wasn't alone in hammering out the specific details of the document. Okay, so this is important, though, that to bear arms means simply to carry them was clear in a game bill drafted by Thomas Jefferson and proposed by James Madison. So when he said bear arms, he meant carry. All right, so thus, in the minds of Thomas Jefferson and James Madison, to bear a gun meant to carry it about in one's hands or on one's person, as for instance, a deer hunter would do. Bearing arms is not associated with militia duty only, for the language above addresses the bearing of a gun by any person when not performing military duty. Further, while the bill would have restricted the carrying of scatterguns and other long guns for hunting, it would not have prohibited carrying pistols for self-defense. At that time, one species of firearms, the pistol, was never called a gun. Okay, so let's read that again. Further, while the bill would have restricted the carrying of scatterguns and other long guns for hunting, it would not have prohibited carrying pistols for self-defense. At that time, one species of firearms, the pistol, was never called a gun. Okay, then what was it called? I don't know. These are just the types of questions when, like, you know, if it wasn't called a gun, like, what did they call it? Right? Because they didn't call it a flower, and they didn't call it a horse, and they didn't, you know, it's, you know what I mean? So there might have been like a technical term for it, just like today with when we call something a pistol versus a rifle. Like, you can have a pistol, but then if it's like over 16 inches, like, there's ways to get around certain laws because they're named certain things, but that doesn't really differentiate like what they're actually known as. Like, if you showed them to everybody in America, everyone would say like, oh, that's a rifle, you know, but if it's small and, you know, it might just fit into this legal category of being a pistol, even though technically it's kind of like a rifle. But if it's under a certain size, you know, so I'm just, you know, this is just important to talk about. And so I'm just kind of spitting this idea in my head as well. So if it wasn't called a gun, then what was it called? You know, it's like they didn't call it a flower. They knew it wasn't a flower. So what was it called? Be interesting to know. Previous game legislation had imposed a possible maximum penalty of 20 lashes on a violator's back. Madison's proposed legislation was intended to make the law more humane. Jefferson strongly relied on the penal reform theories, whose essay on crimes and punishments was partly responsible for the Eighth Amendment's prohibition on cruel and unusual punishment. Interesting. So read that again. Jefferson strongly relied on the penal reform theories of Cesar Beccaria, whose essay on crimes and punishments was partly responsible for the Eighth Amendment's prohibition on cruel and unusual punishment. Very cool. See, this is the thing. Like, they didn't just pull these ideas out of their hats. I said this in my last video on research. The founding fathers were very, very bright people, way smarter than like any of the Americans like we have today. They were well read, they knew their stuff, they knew their history. And so to argue that these people like didn't think this through and they just like didn't think about the fact that, you know, guns were going to change, you know what I mean? It's like, I think it's just stupid. So they didn't just pull these ideas out of their hats. They really, you know, poured over like historical and political documents and were like, let's make the best thing. They didn't just say, hey, let's just like, I don't know, let's like give people the right to bear arms. What does that mean? I don't know. So that's what I'm trying to figure out. What did it mean? In America of the Revolutionary period, Beccaria's little book was more influential than any other single book, its spirit incorporated in documents such as the Bill of Rights. Beccaria's influence on the Second Amendment only recently has come to light. Just months before writing the Declaration of Independence, Jefferson kept a commonplace book where he copied his favorite passages from legal writers. This book may well be considered as the source book and repertory of the performance of various plays, operas, or ballets. Okay, so the source book and repertory of John Jefferson's ideas on government. Okay, whatever. All right, so it's like his idea book. Among the passages Jefferson copied word for word was Beccaria's denunciation of laws which forbid deporter l'armée, which may be translated as to bear, carry, or wear arms. Okay, so again, all this is really important. This is good. Among the passages Jefferson copied word for word was Beccaria's denunciation of laws which forbid to carry, bear, carry, or wear arms. That portion of Beccaria, which Jefferson copied in Italian, writing false ideas of utility in the margin, was worded in the standard English translation of the time as follows. Was worded in this, okay. A principal source of errors and injustice are false ideas of utility. For example, that legislator has false ideas of utility who considers particular more than general convenience. This is going to be like, this is the part where it gets complicated, but who had rather command the sentiments of mankind than excite them. And this is like, this kind of like English goes way over my head. Be thou a slave who would sacrifice 1,000 real advantages to the fear of an imaginary or trifling inconvenience, who would deprive men of the use of fire for fear of being burnt, and of water for fear of being drowned, and who knows of no means of preventing evil but by destroying it. The laws of this nature are those which forbid to wear arms, disarming those. Okay, the laws of this nature are those which forbid to wear arms, disarming those only who are not disposed to commit the crime which the laws mean to prevent. Can it be supposed that those who have the courage to violate the most sacred laws of humanity and the most important of the code will respect the less considerable and arbitrary injunctions, the violation of which is so easy and of so little comparative importance? Does not the execution of this law deprive the subject of that personal liberty, so dear to mankind and to the wise legislator? And does it not subject the innocent to all the disagreeable circumstances that should only fall on the guilty? It certainly makes the situation of the assaulted worse and of the assailants better, and rather encourages than prevents murder, as it requires less courage to attack armed than unarmed persons. Okay, I didn't know where that was going. Again, the first part was kind of hard, and like, I don't know like how much I should go into this, but okay. What he's saying there, and I know I'm getting this right, but you know, we can kind of go over word by word, but this is like a big Second Amendment argument. This is a big pro-Second Amendment argument. If you take away people's guns, they are just going, you know, the only people, if you take away people's guns, if you go door to door and like you search for guns, you take everybody's guns, right? Like, you know, you're not going to get them all, but you know, that's one argument. But if you outlaw guns, right? If you outlaw the right to keep and bear arms and carry guns and constitutional carry and all that stuff, the only people that are going to follow that are the law-abiding citizens, the people who would not have like hurt people with the gun in the first place. The people who are not going to follow it are all the people who are going to hurt people. So the only thing you're doing is making the victims more vulnerable than they otherwise would have been, because now they can't protect themselves with a gun. So the wisdom of Beccaria was a source of Jefferson's proposed Virginia Constitution of 1776, which provided no freeman shall ever be debarred the use of arms. An avid hunter and gun collector, Jefferson carried pocket pistols, which may be seen today at Monticello. Okay. John Adams began his opening statement in the Boston Massacre trial in 1770 with a quote from Beccaria, and in the course of his speech be added that the inhabitants had a right to arm themselves at that time for their defense. Adams's own views against disarming the people were certainly consistent with the following favorite passage from Beccaria, which he copied in his diary. Every act of authority of one man over another for which there is not an absolute necessity is tyrannical. Love that. Love that. Wow. I need to, one sec, I'm sorry, but that is like, that's a fantastic quote. File, new note, quotes. That is, I mean, that's just way too good to pass up. Sorry, people, you're gonna have to wait a second because that was just so beautiful. Beccaria. Come on, transfer over. Yes. Beccaria. Who's that? John Adams. Okay. John Adams. Copied in his. Okay, this is sounding pretty pro Second Amendment. I'm not sure where this is going. It sounded like it started out anti Second Amendment, but I don't know how this is working out. Adams upheld the right of arms in the hands of citizens to be used at individual discretion in private self-defense. So he upheld the right of arms in the hands of citizens to be used at individual discretion in private self-defense. Bearing arms for personal protection was an unquestioned right in the minds of the founding fathers. Before the Revolution, James Iredell, who would be prominent in the struggle to ratify the Constitution and later a justice of the United States Supreme Court, wrote to his mother, "Be not afraid of the pistols you have sent me. They may be necessary implements of self-defense, though I dare say I shall never have occasion to use them. It is a satisfaction to have the means of security at hand, if we are in no danger, as I never expect to be. Confide in my prudence and self-regard for a proper use of them, and you need have no apprehension." Beautifully written. Have you ever written a letter like that to your mom? If I ever wrote a letter like that to my mom, she'd be like, "Are you on drugs?" That's so, they used to write so beautifully. Like, that's what I'm saying. They're like such smart people. In 1775, North Carolina's delegation, so a year before the ratification of the Declaration of Independence, the signing of the Declaration of Independence. In 1775, North Carolina's delegation to the Continental Congress, all of whom became prominent state or federal leaders, resolved, it is the right of every English subject to be prepared with weapons for his defense. Okay, but they were all English subjects. So that's kind of like saying it is the right of every American to be prepared with weapons for his defense. William Henry Drayton, a prominent revolutionary leader and Chief Justice of the South Carolina Supreme Court, always had about his person a dirk and a pair of pocket pistols for the defense of his life. Okay, this is all, okay, I'm going to start reading, like, this is all very pro-Second Amendment stuff. Up in Vermont, Ethan Allen and his friends never walked out without at least a case of pistols. Lodging with a Quaker on one occasion, Ethan's brother Ira recalled, "We took our pistols out of our holsters and carried them in with us. He looked at the pistols, saying, 'What doth thee do with these things?' He was answered, 'Nothing amongst our friends, but we were Green Mountain boys and meant to protect our persons and property.'" Just 10 days after James Madison proposed the Bill of Rights to Congress in 1789, Tench Coxey, a prominent Federalist and lifelong correspondent of Jefferson and Madison, wrote that what became the Second Amendment would confirm the people in their right to keep and bear their private arms. James Madison, okay, this sounds like it's a very pro-Second Amendment thing. It sounds like what happened is that these people, who are these people? This is page 5. Okay, so, what's this guy's name? Professor Don Cates and whatever this other guy's name is, Professor Lawrence Kress, they're arguing some stuff, and whoever's writing this, freedom-loving American Stephen P. Holbrook, it sounds like, is basically tearing their argument to shreds, basically going line by line saying, hey, this is what they meant. Okay. James Madison endorsed a widely published article in which these words appear. Coxey's writings provide unmistakable evidence that 18th century Americans defined muskets, rifles, and pistols as arms. Okay, Coxey's writings. Okay, so Tench Coxe, a prominent Federalist and lifelong correspondent of Jefferson and Madison, right? The Madison penned the Declaration of Independence, and I just want to make sure who wrote that was, yeah, James Madison. Okay. And then who wrote the Bill of Rights? James Madison, right? The Bill of Rights. Who penned the Declaration of Independence? Okay, Thomas Jefferson. Okay, so Thomas Jefferson, I was thinking James Madison might have done all of them, but he didn't. Okay, so Thomas Jefferson wrote the Declaration of Independence. James Madison, Constitution, Bill of Rights. Okay, so this guy, Tench Coxe, was a prominent Federalist and lifelong correspondent of the two people who signed the Declaration of Independence and wrote the Bill of Rights and the Constitution. And he said that Coxe's writings provide unmistakable evidence that 18th century Americans defined muskets, rifles, and pistols as arms. I would like to know, okay, 34, Coxe to the public, Democratic Press, February 2, 1811 at 2. Okay, so this is what I'm saying. This is a good article because I would then have to go and read to the public. Let's see if, you know what, let's just test this out real quick because this is what I don't want to just skip over all this stuff, right? This sounds like it's good, but I want to, this guy is giving source materials. When he is saying, this is what my argument is, he's like, go to look at all of these source documents. He is literally saying, listen, I'm not telling you to take my word for it. Go and look at what these people were writing. Okay, so let's just try and look one up real quick. Tench to Coxe. 34, Coxe to the public. Okay, let's just type this in and see what comes up. Okay, now, let's see. Okay, so and that they endorsed an individual right to own and keep and use arms and consequently of self-defense and of the public militia power. So let's put that into this. How do you, sorry guys. Okay, sorry. How to search a document on a Mac. Okay. Click the spotlight icon. It looks like a magnifying glass in the menu bar in the top right corner of your screen. Oh, okay. That's what I'm trying to do. How to search a website for a certain phrase on a Mac. Control, command key. Okay, command key. While holding that key, also press down the F. Okay, sorry. I was thinking it was S, but it's F. Okay, so Apple F. There we go. Apple V. Okay, I can't find it. Oh, okay. This isn't. Okay, but this isn't the whole thing. This isn't introduction. Okay, this isn't the actual document. So oh, this is the whole document. It's 42 pages long. Oh, so this is also by Stephen P. Holbrook. And he literally writes an entire thing on Tench Coates. Okay, so this is like, I'm not just, I can't go around searching forever, but this guy wrote an entire article. Look at this. Like, this dude has done his research. Look at this. This is nutso supremo, dude. Look at all of these citations. Every single page, he's like, this is where I got it from. This is where I got it from. This. So you know exactly what he's talking about. This is, when that guy, what was his name? What was his name? The Washington Post. I don't know. I forget his name. Doesn't even matter. But when he, he's like above average historian. He said that on his Twitter handle. This, sir, is an above average historian. All right. So, I don't know. Like, when someone seems like they're being trustworthy, you can trust them. Okay. And I'm not just saying that, but like, I can't scour the internet for the next 2 hours. Like, I'm trying my best here. But this guy is giving us strong evidence and clear indications that he's trying his best to tell the truth. So, far better than someone who literally gives you no citations and like you could pick apart every single thing line by line. Okay, so his own firearms are the second and better right hand of every freeman, held Coates. His own firearms are the second and better right hand of every freeman. What a great, gosh, this is a great document. Sorry, Coates. Okay. In the 1830s, Madison wrote, "A government resting on a minority is an aristocracy, not a republic." And could not be safe with a numerical and physical force against it without a standing army. Okay, so this goes back to our last one, where he was saying that the founding fathers were very scared of a standing army, and with good cause, right? Because this was the issue that they faced with the British Army. So a government resting on a minority is an aristocracy, not a republic, and could not be safe with a numerical and physical force against it without a standing army and enslaved press and a disarmed populace. The founding fathers in general strongly endorsed the right to bear arms for self-defense. They gave written expression to their views through the Second Amendment and personally exercised the right by owning and possessing arms. The same linguistic, I was hoping that I was like, man, this looks like an intense article and it might be hard for me to combat this. So, but this is honestly, this is my argument. I do believe that if you go back and you look in context to what the founding fathers meant, they did not, they weren't just saying the militia. They weren't just, they carried guns themselves. They were just practicing. They were just preaching what they were practicing. And I knew it, dude. I knew it. I knew that if I went back and looked, all these crap arguments that they just didn't know what they were talking about just would not hold water. Okay. This is fantastic, dude. This is amazing. The same linguistic usage of the terms bear and arms prevailed during the period of the adoption of the 14th Amendment, which was intended. Okay, I don't know all the, I'm not a historian like this. Okay, so maybe I should know what the 14th Amendment is, but no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law. Okay. Nor deny to any person within its jurisdiction the equal protection of the laws. Okay. Okay, so I think that's what the Bill of Rights, not the Bill of Rights, the Equal Rights Act of 1964 was all about, right? That was the 14th Amendment, right? That you can't discriminate based on like race, sex, physical characteristics. Okay, the same linguistic usage of the term. So I'm not totally incompetent when it comes to history. I just don't know all the constitutional amendments. The same linguistic usage of the terms bear and arms. Okay, so for instance, in 1865, I'm starting right here. So in 1865, Florida made it unlawful for any Negro, mulatto, or other person of color to own, use, or keep in his possession or under his control any bowie knife, dirk, sword, firearms, or ammunition of any kind, unless he first obtained a license to do so from the judge or of probate. Violators faced a possible penalty of 39 stripes with a whip. The commission that drafted this legislation opined that the privilege of bearing arms should be accorded only to such of the colored population as can be recommended for their orderly and peaceable character. Okay, so The same linguistic usage of the terms bear and arms prevailed during the period of the adoption of the 14th Amendment, which was intended to incorporate the Second Amendment. For instance, in 1865, Florida made it unlawful for any, okay, all right, so, 80 years afterwards, they were still using, let's see, first 10 license, okay, for any Negro, mulatto, or other person of color to own, use, or keep in his possession or under his control, okay, the privilege of bearing arms should be accorded only to such of the colored population as can be recommended for their orderly and peaceable character. Okay, so this is what the other guy was arguing, that, people would take away people's rights to bear arms. This goes directly, this is great. I love this. So this document and what this guy is talking about and the source material that he is providing, this goes directly against the last article that we read about in the Washington Post, because he was arguing that because, the founding fathers and Americans, the early government took away the rights to keep and bear arms from Black people and or Native Americans, that for some reason, I don't know, that somehow affected our Second Amendment rights. And what this is saying is, and he's not directly countering that, but what he's saying is that the idea of keeping and bearing arms was constantly used even up to 80 years afterwards in the same context as it was used in the Bill of Rights. So members of the Reconstruction Congress, state constitutional conventions of the time, and mainstream white and even Black newspapers cited protection of the right of freedom of freedmen to bear arms to protect themselves and their families from infringement by sheriffs, militias, and the Ku Klux Klan as a major object of the 14th Amendment and the Civil Rights Act, including what is now 42 U.S.C. 1983, which I believe, let's look that up. 42, is that the Civil Rights Act of 1964? But technically it was civil action for deprivation of rights. No, it's different. Section 1983 provides an individual the right to sue state government employees and others acting under color of state law for civil rights. Okay, so it's about suing people. Okay. All right, so something else. See, that's what I want to do. I just take it line by line and we'll research when we need to. While the Reconstruction Congress interpreted the Second Amendment, buttressed by the 14th as protecting the rights of freedmen. Let's read that again. While the Reconstruction Congress interpreted the Second Amendment, buttressed by the 14th. So I think buttressed is strengthened, right? Backed up by the 14th as protecting the rights of freedmen and even former Confederates to keep and bear private arms. It abolished the Southern state militia organizations, denying a Second Amendment protected right of states to organize militias. It abolished the Southern state militia organizations, denying a Second Amendment protected right of states to organize militias. Okay, all right. I'm not sure exactly what that means. Okay, although the real issue is the Morton Grove, Illinois handgun ban, America's first, involved the right to keep rather than to bear arms, the brief of Handgun Controlled Inc., HCI, claimed the language of the Second Amendment suggests that its purpose is limited to protecting organized and effective state militias. So this is where it all started. This is where it all started. But this is good to know. The terms arms and bear arms have always been associated with organized military activity. Yeah, but take up arms. Yeah, I mean, that doesn't mean that that's the only people. Okay, let's just keep reading. The chief authority cited by HCI for this proposition is Noah Webster's famous 1828 dictionary. Okay. Anyone who looks up Webster's definition of bear will be startled to find the very opposite of what HCI claimed. To bear as a mark of authority or distinction, as to bear a sword, a badge, a name, to bear arms in a coat. Although HCI also referred to Webster's definition of arms. This is fantastic. I'm actually going to save this because this is, I'm going to look up 11.14.23, research source document. This is a fantastic article. Okay. Anyone who looks up Webster's definition, keep and bear arms in a coat. Okay. As to bear a sword, a badge, a name. To bear arms in a coat. Interesting. So the first one, anyone who looks up Webster's definition of bear will be startled to find the very opposite of what HCI claimed. I wonder if we look up Webster's dictionary, Webster dictionary, see what they say now. To be equipped or furnished with something. Sounds like that's where it would have been. To hold in the mind or emotions, to behave, conduct, disseminate, lead, to give birth to go or incline, to be suited, to become directed, to force one's way, to support a weight, to join in, bear arms, to carry. Okay, interesting. To carry or possess arms. The right of the people to keep and bear arms, to carry or possess arms. Okay, so I think we're all right. Touche, Webster's. Thank you for not changing your definition. I just heard that there were some words that were getting finagled around recently. Okay. So, although HCI also referred to Webster's definition of arms, this again fails to imply an exclusively military usage. Weapons of offense or armor for defense and protection of the body, consistent with the meaning of bear arms as carrying or wearing weapons on the person or inside one's clothing. Webster defines pistol as a small firearm or the smallest firearm used. Small pistols are carried in the pocket. As to who has the right to bear arms, Webster defined the people as the commonality as distinct from men of rank. Interesting. Okay, so when he was, so what this is saying is that, talking about, it's always been associated with, let's see. So the HCI, the Handgun Control Incorporated, claimed that the language of the Second Amendment suggests that its purpose is limited to protecting organized and effective state militias. But then if you go into Webster's dictionary at the time, the people were defined as the commonality, as distinct from men of rank. All right, I don't want to keep doing source documents, not because I don't believe him, but this guy seems to have done his research. Every time I try to fact check him, the dude is on point. Webster was certainly in a position to know what the Second Amendment phrase bear arms meant. A prominent Federalist, he wrote the first major pamphlet in support of the Constitution when it was proposed in 1787, in which he stated, before a standing army can rule, the people must be disarmed. He wrote a pamphlet in support of the Constitution when it was proposed in 1787, in which he stated, before a standing army can rule, the people must be disarmed, as they are in almost every kingdom in Europe. The supreme power in America cannot enforce unjust laws by the sword because the whole body of the people are armed. Right there. Gosh. Cheers. Cheers, Mr. Webster. Man, you would, love it. Webster was certainly in a position. I'm literally just going to tell people, and this is honestly, this is just saying that when you say bear arms, all this is saying is that it means to carry them. It means to carry them. What we do have to now determine is what it meant by militia, so this is, I think, giving us good ammo to say that bear arms does not mean own them, right? This is giving us source documents and definitions and quotes from people saying that, when they say bear arms, they meant to carry them. Webster was certainly in a position to know what the Second Amendment phrase bear arms before a standing army can rule. Okay. When the Morton Grove case was still, okay, I will be honest though, the Supreme Court power in America cannot enforce unjust laws by the sword because the whole body of the people are armed. But that doesn't mean, it doesn't talk about carrying it day to day. When the Morton, outside your home, when the Morton Grove case was still before the United States Court of Appeals for the Seventh Circuit, unassailable evidence was presented that the respective framers of the Second and 14th Amendments intended the individual right to keep arms, including pistols, to be protected from the infringement by the federal, state, and local governments. The intent of the framers was so overwhelmingly contrary to the court's opinion upholding the gun ban. So the intent of the framers was so overwhelmingly contrary to the court's opinion upholding the gun ban that the court held that intent to be irrelevant. In contrast, the Supreme Court has stated repeatedly that the Constitution's provisions must be interpreted according to the intent of the framers. That is crucial to understand. What arms are protected? As the Oregon Supreme Court recently opined in the state constitutions adopted between 1776 and 1802, the term arms, as used by the drafters of the constitutions, probably was intended to include those weapons used by settlers for both personal and military defense. The term arms, probably. Okay, all right. So the term arms by military defense. Okay, he doesn't cite any source documents here, so let's see what he comes up with. The term arms was not limited to firearms, but included several hand-carried weapons commonly used for defense. As the Supreme Court recently opined, in the state constitutions adopted between 1776 and 1802. Okay, so the Oregon Supreme Court said, this is a quote, the term arms has, as used by the drafters of the constitutions, probably was, I missed that quote, was intended to include those weapons used by settlers for both personal and military defense. The term arms was not limited to firearms, okay, and included several hand-carried weapons commonly used for defense. Under the Second Amendment, all commonly possessed arms which an individual could keep and bear would be constitutionally protected. But then and now, these arms include firearms, edged weapons, and blunt instruments. Okay, that, I don't know. I mean, I'm definitely a pro-Second Amendment guy, obviously, but it would make sense that if you can keep and bear it, then you should be allowed to have it, right? Because I'm like dying here. I'm getting tired. Second, man, I'm gonna remember this eventually. And then a well-regulated militia, being necessary to the security of a free state, the right of the people to keep their arms shall not be infringed. Okay, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay, under the Second Amendment, all commonly possessed arms which an individual could keep and bear. So that makes sense. If you can keep and you can bear it, you could carry it on your person, right? And we've already gone through what bear means, then you should be able to have it. I would argue that that means more than guns, but we'll see. The most clearly protected firearm is the rifle. The use of which for self-defense, even in urban areas, is protected by the Second Amendment, guarantee of the right of the individual to bear arms. 55 cites another, look at all these citations right here. He just goes to town on citations. This is great. The modern descendant of the man highly penetrative. I don't know what just happened there. I'm not sure what just happened. Hopefully this whole thing has been recording, because if not, that's going to be a bummer. Okay. So remember the guy up top said that, you know, we have a right to keep and bear arms, but rifles, shotguns, and highly penetrative pistol rounds should be outlawed from private use. And what this guy is saying is the short-barreled shotgun, remember, because he said gangster weapon, short-barrel shotgun. The short-barrel shotgun is the descendant of the blunderbuss, a classic home defense arm. So you have to go back into the context of what they meant during that day, in contrast with the long-barreled hunting shotgun known traditionally as the fowling piece. While it may not be within judicial notice that the short-barreled shotgun is a militia arm protected by the Second Amendment, such an arm has been factually determined to fall within the state constitution, protecting the right of citizens to keep and bear arms for their common defense. The arm most commonly possessed for self-defense is the pistol, due to its ease of storage, carriage, and accessibility. That is exactly why I'm making my company. Pistol, XV termini, is properly included within the word arms, and the right to bear such arms cannot be infringed. It's short. Okay, this is like starting to quote a lot of things and not talking about a whole lot. So its short barrel makes it difficult for an assailant to grab, and its size, weight, and simple mechanism makes it used for variable for women, the elderly, and the handicapped. Smaller pistols. Okay, this is talking about the smallest handgun designed by Smith & Wesson was such a small revolver that it was nicknamed the Lady Smith, since it seemed to be more suitable for a woman's small hand. The relatively high cost of rifles as compared to pistols suggested a ban on the ownership or possession of low-caliber handguns would effectively negate any right of the poor to bear firearms for their self-defense. There has been little scholarship concerning Canada. They just banned the sale, purchase, and transfer of pistols in October of last year. So look at this. There has been little scholarship concerning whether certain edged weapons and blunt instruments are arms in a constitutional sense. The knife is one of mankind's oldest tools and weapons. Pocket knives were in use when the Second Amendment was adopted. It is questionable whether switchblade knives with the modern convenience of a spring-assisted blade may be banned any more than could modern firearms, which no longer rely on a flintlock mechanism. Interesting. That's a very cool argument. So just like, we don't rely on a flintlock, where you put the little thing on there and you pull back the hammer and it hits the flintlock. We have, rounds, bullets that encase everything, but just because it has a different mechanism that it uses to fire, doesn't mean that gun is outlawed. Just like, blades were legal back in the day, but just because you have a switchblade that uses a different mechanism, it's still a blade. So why are states allowed to ban? I mean, that totally, this is what I'm saying. That makes sense. Right? It's not like the framers, they thought, oh, what happens if you take a blade and then it pops out? No, that's not legal. They're clearly, that's not, just going through the source material, that's not at all what they meant. The staff in the club, mankind's oldest defensive weapons, are clearly constitutionally protected. Since arms under the Second Amendment are those which an individual is capable of bearing, artillery pieces, tanks, nuclear devices, and other heavy ordinances are not constitutionally protected. Okay, since arms under the Second Amendment are those which an individual is capable of bearing, artillery pieces, tanks, nuclear devices, and other heavy ordinances are not constitutionally protected. I think that makes sense, right? So this is exactly, frankly, I have always honestly argued, or not argued, but I have thought, I haven't argued. And actually my brother, who passed away, he thought that private citizens should be able to own atomic bombs. When he told me that one time, I was like, dude, what? And he's like, yeah, anything that the government is able to own, I think private citizens should be able to own. And I was like, that's a little nuts. And I would have loved to have been able to say keep and bear. You have to be able to bear it. And if you go back to the source documents, bearing means to carry. You have to be able to carry it. And if you can't carry it, then it's not constitutionally protected. And this is, the Constitution can change. It is, a living document because we have updated it before. But if we want to update it in order to include ordinances, then we would have to update the Constitution. I think I totally agree with that. Nor are other dangerous and unusual weapons such as grenades, bombs, bazookas, and other devices which, while capable of being carried by hand, have never been commonly possessed for self-defense. Okay, that's where I would, disagree, I guess. I've always, thought that having grenades and things like that for self-defense, especially from the government, I think is important. But nowadays, frankly, that's not as important because Afghanistan, Iraq, the Taliban and all those other groups, they went to town on Russia and the US with just homemade IEDs for years, and they killed tons and tons of people and wreaked havoc on Russian and American soldiers. And they never, they had bazookas, grenade launchers, but IEDs are super, super effective. So, all right, keep going on. So blunt and edged instruments and firearms are capable of being used against a violent assailant in such a manner as not to endanger the innocent. In contrast, explosive devices may be incapable of pinpointing an aggressor, thus harming the innocent as well as the guilty. Interesting. See, that's good argument, dude. That makes you think. It's not oh, guns are allowed, but explosives aren't. Why not? Give me a reason. And this guy's given, that's a solid argument, right? Explosive devices may be incapable of pinpointing an aggressor, thus harming the innocent as well as the guilty. So, very interesting. No one would seriously argue that citizens must, and so I have to say, I want to go through this and I'm keeping an open mind. So as of right now, I think it makes sense that if you're taking the Constitution as written, right, explosive ordinances would not be included. But I guess, sorry, I'm going to go through this one more time, and I'm not trying to pick this apart. Where did he say? I felt like it kind of jumped for a second. There's been no scholars concerning whether certain edged weapons and bloodshed are arms. Since arms under the Second Amendment are those which an individual is capable of bearing. Okay, but then he talks about self-defense. He jumps to self-defense, nor are other dangerous and unusual weapons carried by hand have never been commonly possessed for self-defense. Okay, but now he's jumping like only to self-defense. So we're not able to keep and bear arms for a militia, or is he just focusing on the right to keep and bear arms for self-defense? I think, okay, so maybe that's what he's doing. He's talking about you have the right to keep and bear arms for self-defense, but because that has never, like, people have never carried that. It's like, just like I was saying, I think in my last video that, it's common knowledge that people are, I was talking about RFK Jr. and he was saying that, back in the day, you were able to have guns and, you were able to like bring them places and stuff like that. And, New York, or sorry, DC versus Heller, it enshrined the right to keep and bear arms without being part of a militia. And I was saying in my last video that, sorry, my head is like all over the place. It is so filled with new information. This is crazy. But I was saying that it's honestly, it's one of those things that it's so commonly understood that you wouldn't even have to say it. And I was, I have to be consistent in my beliefs. And so if it's so common and understood, you don't even really have to say it. Then I also have to be consistent when I say that this is also true, right? There has been little scholarship since arms under the Second Amendment are those which an individual is carrying, grenades, bombs, and bazookas, have never been commonly possessed for self-defense. Is that true? Yes, that is absolutely true. And so if we're talking about, do you have a right to keep and bear arms for self-defense outside the home? Does that include bombs, grenades, bazookas? No, absolutely not. Okay, that's fair, right? I got to be consistent. I want to be consistent. I want to think this through, and I want to have good, sound arguments. I want to be able to back my ideas up with evidence. So do you have a right to keep and bear arms, any type of explosive ordinance outside the home? Absolutely not. I think that is, yeah, you gotta go with the source material and you gotta go with what makes sense. Good. Now, if you disagree with that, then that's fine, right? But you don't have any legal basis to disagree with that. That's the argument, right? We're talking about the legal argument to keep and bear arms. You do not have a legal basis to say that you can carry around a grenade, right? Because of what this guy is saying. So in contrast, explosive devices may be incapable of pinpointing an aggressor. Okay, so no one, all right, so our registration and licensing infringement. No one would seriously argue that citizens must register with the police or obtain a license in order to exercise freely their political or religious beliefs. Great point. Requiring citizens to register or obtain a permit if they object to unreasonable searches and seizures of their persons and homes would clearly infringe their rights, except where there is limited space in public forums, which requires fair allocation. Authorities cannot require persons giving speeches and assembling to obtain permission to do so, nor may the anonymous keeping and bearing of arms by law-abiding citizens without more constitutionally be the subject of registration and licensing. To be sure, armed marches in a city, like other assemblies in public places, may be the subject of a license requirement. When the possibility of tyranny exists, however, the people cannot be denied their rights of associating, arming, and fighting in defense of their liberties. Okay, so sometimes you can be required to get a permit in public places where limited space in public forums, which requires fair allocation. That's an example of a place where it's legal to require permits. In a true republic, this is glorious, dude. The people may arm and associate without anyone's permission. Although violent criminals, children, and those of unsound mind may be deprived of firearms, enforcement of such a prohibition would not be materially aided by requiring ordinary citizens to register or obtain licenses for their firearms. Throughout history, Okay, notice that. Okay, so I guess that would be the hiccup though nowadays, right? So how do you differentiate the two? That would be, I want to like give the other side their due. Although violent criminals, children, and those of unsound mind may be deprived of firearms, enforcement of such a prohibition would not be material aided by requiring ordinary citizens to register or obtain licenses for their firearms. So how do you make sure that those people, when they go to purchase a pistol, are not required or not getting firearms? So the main people, obviously, if a kid walks in, they're just not getting sold to. But the criminals and the mentally disabled, that's the, or not disabled, the mentally unsound nowadays, those are the two categories. How do you make sure they're not walking into a store and getting guns, right, without infringing on the rights of other Americans? I don't know. I don't know. Hopefully, maybe he talks about this. Throughout history, firearms registration classically has been required as a prelude to confiscation. Let's read that again. Throughout history, firearms registration classically has been required as a prelude to confiscation. What is 73? Many antique Irish and Scottish firearms have registration marks made pursuant to English measures designed to conquer those nationalities. Interesting. It is well known that the Nazis used registration lists to confiscate guns and to find and execute gun owners. All right. The English Bill of Rights provision that subjects may have arms for their defense was passed in direct response to a registration/confiscation scheme. The English Bill of Rights provision that subjects may have arms for their defense was passed in direct response to a registration/confiscation scheme. The anonymous keeping of firearms acts as a deterrent. The anonymous keeping of firearms acts as a deterrent to governmental oppression, whether by a racist local sheriff or a coup-minded military junta. Creation of yet another victimless crime, that of exercising a constitutional right without first registering with the government, can only promote a burgeoning police state to enforce it while convicting the innocent. And this guy's on fire. A requirement that one may not exercise the right to bear or carry arms, either openly or concealed, without a license is also constitutionally defective. Until the 14th Amendment was adopted, licenses to carry arms were only required for slaves and blacks, while free men could carry arms openly, but not concealed. Today, some states require a permit only for carrying concealed weapons, while others require a permit for bearing arms either openly or concealed. The arbitrary denial of licenses and permits in many states and localities would be alleviated to some extent by granting the aggrieved party automatic review and a right to receive attorney fees. Conclusion: the framers of the Second and 14th Amendments intended to guarantee an individual right to carry firearms and other common hand-carried arms. It is inconceivable that they would have tolerated the suggestion that a free person has no right to bear arms without the permission of a state authority, much less the federal government, or that a person could be imprisoned for doing so. As the founding fathers realized, every right has its costs, but the alternatives are often more costly. I'm going to read that one more time because that is just absolutely fantastic. Just the last sentence. It is 2 cents. It is inconceivable that they would have tolerated the suggestion that a free person has no right to bear arms without the permission of a state authority, much less the federal government, or that a person could be imprisoned for doing so. As the founding fathers realized, every right has its cost, but the alternatives are often more costly. I think that's a great place to end it. I don't think I could say it any better than that. So until next time, I hope this was helpful. This was very, very eye-opening for me. Until next time, stay safe, live free, and I will talk to you later. See you guys.